4, 3, 2, 1.
This Honorable Court of Criminal Appeals of Tennessee is now in session.
This is a continuation of the February docket, the Western section of the Court of Criminal Appeals. On the panel, Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis. I'm Kelly Thomas from Maryville. 20 minutes aside. If the appellant wants to reserve some rebuttal time, please tell me when you start your argument. And our continued appreciations to our Supreme Court Clerk Jim Hivner and Nick Morgan and Barbara Peck for working with us and making this possible. Call the next case, please.
State of Tennessee versus Russell Wheeler, Jr.
On behalf of the appellant.
Good morning, Your Honors. May it please the court. My name is Jessica Butler with the Appellate Division of the Public Defenders Conference. On behalf of the appellant, Mr. Wheeler, with the court's permission, I'd like to request 2 minutes for rebuttal.
That'll be fine.
Thank you. Mr. Wheeler was convicted by a Madison County jury of attempted aggravated statutory rape and attempted solicitation of a minor, a crime that does not exist. Mr. Wheeler was also convicted of disorderly conduct, but that is not at issue in this instance. Today, we're asking the court to vacate Mr. Wheeler's conviction for attempted statutory rape because the state did not prove that Mr. Wheeler took a substantial step towards completing that crime. Additionally, we're asking the court to vacate the judgment for attempted solicitation of a minor, as this is a legally impossible offense. I'd like to begin with the attempted rape allegation. Specifically, our issue is the substantial step portion of this. Obviously, the court knows that attempt requires the defendant to have an intention to see the completed crime come to fruition. It also requires that the defendant take a substantial step towards completing that crime. And the statute dictates that conduct does not constitute a substantial step unless the entire course of action demonstrates an intention to commit that offense. And this seems to be the biggest separation between our position and the state. Essentially, the state is arguing that Mr. Wheeler took several substantial steps towards completing the crime, but it seems to be prematurely cutting off where we determine the course of action has ended. Essentially, the state's position is that each instance that Mr. Wheeler attempted or asked for oral sex was a substantial step towards completing the crime. And it's
they're not just relying on his speech; they're also relying on his actions. Did he not pull his pants down and masturbate in front of the victim after he asked her to perform fellatio?
That's correct, Your Honor. And our position is that they're cutting off where we should be looking at the full course of action. So yes, the state should absolutely be looking at those instances, but additionally, the state is cutting off Mr. Wheeler's course of action prior to him deciding to call the whole thing off, putting his pants on and getting back into bed, where he remained until the police arrived. And so we have to look at all of the events of that night, not just the specific instances that the state claims were substantial steps. That the entire course of action really covers the full breadth of that night. And in our brief, we cited State versus Reeves as well as State versus Fowler to provide some context and guidance on when the course of action should be cut off. Essentially, in both of those cases, the defendant's course of action is cut off at the moment that they are arrested or caught, or essentially their plans are foiled. And that's not what we have here. We have instances where Mr. Wheeler presented a note. We have the instance where he asked for oral sex. We have the instance where he came out of the bathroom unclothed or partially clothed. But we also have Mr. Wheeler deciding to call the whole thing off. We have Mr. Wheeler putting his clothes on, getting into bed, staying there until the police were called, which he had no knowledge of. And so we have to look at the entire course of action that night, not just those specific instances. And I believe that Reeves and Fowler kind of provide some guidance on when the defendant's full course of action is cut off. It has to be cut off at the moment that the plans are foiled. And that's not what happened here.
Well, I mean, I guess I'm just not following your argument very well then. And it's probably me and not you, but an attempt, a crime is attempted once the attempt fails, or once, the defendant stops it, then that the attempt crime is completed. I don't know why his actions, once she told him no and he got in bed, he, at least up until that point, attempted a crime. Just because he didn't do anything after that, how is that relevant?
Well,
I mean, is that your argument? Your argument wants us to focus on the stuff he did after the attempt was completed, but the attempt was completed when he made numerous overtures to her, both physically and orally, and then for whatever reason, because she kept saying no, or maybe he got a guilty conscience finally, or whatever the case may be, the attempt to engage in statutory rape ended at that point. The crime had been committed, had it not? Why does what happened 2 minutes later, 2 hours later, 2 days later matter?
Well, I think there's a gradient. I think that there's a difference between the substantial step in the legal sense and these specific actions adding up to that substantial step. That yes, he could have taken steps, but they don't necessarily rise to that substantial step level that we need to form the attempt. That statutorily, conduct has to include the entire course of action. And it's not just his asking, it's not just the note, it's also his withdrawal from the situation, his physical removal from the situation, his withdrawal from the situation. That is the entire course of conduct, because his actions are not cut off really until the night is over. That essentially we have to, yes, absolutely, we have to consider the note, we have to consider the ask, but we also have to consider his withdrawal from the situation, his removal.
Only focusing on his ask. He did more, or at least the briefs bear out more than mere speech. And that's what I want you to focus on. I understand your argument on the attempt stat rape, wishes us to focus on, the timing of everything. But I guess my point is a substantial step in the commission of the underlying offense can mean a lot of different things and can add up to a lot of different things. And here, what I'm hearing you say is we're going to ignore the defendant's acts of the note, the physical acts, the note, and the masturbation, and he put his hand on her head. These are things that all occurred before he retreated. And so in my mind, I get what you're saying. You're saying, you still have to consider the fact that he retreated. Well, that's the whole concept of an attempt. Again, I'm following what you're saying, but you seem to be ignoring the fact that there was more that led him to retreat from his preparatory acts of perpetrating the underlying offense.
No, not at all, Your Honor. I'm not ignoring those facts at all. Obviously, those are things that are in the record. So we're not ignoring those facts at all. I think what we're simply saying is that the conduct involves more than just those actions. Yes, those actions are part of the calculus, but they're not the whole picture. And the state's argument seems to be that those actions are the whole picture. We're simply saying that you have to consider kind of the full scope of what occurred that night, not that we're trying to discount those actions at all. And those actions, separate and apart from the allegation of attempted aggravated statutory rape, sure, they may be separate crimes, but even if we take all of them together, if we couple that with everything that happened that night, the full scope of that night does not rise to the level of an attempted aggravated statutory rape. We're not discounting that those actions occurred at all. Absolutely not. But we're saying that we're asking the court to consider more than just those actions.
So how does considering everything that happened negate the fact that there was a substantial step taken? Tell us how does that work?
Well, so we're saying that if you look at the full scope of what occurred that night, a substantial step was not taken. That because the statute requires the court to look at the entire course of action, that the state can't cut off the course of action simply after the note or after the masturbation. It has to consider the full panoply of what happened that night.
So you're saying that any time a defendant is rebuffed and or retreats after being rebuffed, there is no substantial step?
No, I don't think that's quite it.
Sure sounds like it.
So I think what we're saying is that the entire course of action, there obviously has to be a cutoff point for when the entire course of action ends. And that the entire course of action can't simply end at the moment immediately after the act. That's not where the entire course of action ends. That basing our argument on Reeves and Fowler, that the entire course of action comes to an end when the plans are foiled, the person is caught, arrested, something in that vein. And that's not what happened here. That if we look at the entire course of action, that has to include the retreat, the withdrawal, and that is not a substantial step.
Let's change the fact pattern a little bit, and something that's a little more clear. I mean, though I think this is very clear, but a little more clear under the law. A theft occurs when the taking is completed, correct?
That's correct.
All right. So I walk into a store and I take a candy bar and I walk out of the store. Theft. No question about it, correct?
Yes.
I'll then come back because I get down the block and I have a guilty conscience and I bring it back and give it back to the store owner. Are you saying I have to consider my subsequent actions before you can convict me of the theft, which it's clear I committed?
No. So in that instance, I think once you've left the store, the theft is completed. I think what we have here is a situation. Sorry, go ahead.
No. So you're answering my question. So once I've left the store, the theft is completed. What I do subsequent doesn't matter. So once the defendant, in this case, has made numerous comments, has presented himself partially clothed while making one of those comments, and other actions that he does, even though she rebuffs him and says no, and he withdraws because, much like my theft person, has a guilty conscience or whatever reason he decides to give up the ghost there, the attempt is completed, is it not? Regardless of what he does the rest of the night.
Not necessarily, Anna. So going back to your theft example, this instance is more akin to someone going into a store, picking up a candy bar, thinking to themselves, I'm going to take this without paying for it, telling someone that, close by, I'm going to take this without paying for it, walking, past the counter thinking, I'm not going to take this, I'm going to take this, and then turning around and putting it back on the shelf. That's really what we have here. And the question is that an attempt at theft? It was never completed, and it was really, kind of limited to thoughts and actions without actually taking the step to walk out of the store and attempt to theft.
Actually, the state would probably argue under that scenario that the second you walked past the counter, the point of sale with that candy bar, you completed the theft. But that's not our fact pattern here. I just had used the theft to make it's just more defined. Once the taking's complete, it's complete, and it doesn't matter what happens after that.
Sure.
I think the attempt to commit a crime I get your point in that there's a bigger picture when you're looking at attempts, trying to figure out what was his intent. Was there enough to constitute an attempt to commit a crime? But I think in this case, there's clearly his actions leading up to his finally just saying, oh, well, it's not going to work, are sufficient to establish an attempt.
Respectfully,
And the only thing that I'll-
go
The
ahead.
only thing
Go
that
ahead,
I'll
Gary.
add to that is I get the impression from listening to you go back and forth with Judge Dyer that you really want us to read into more. You want us to read into the fact that this particular defendant retreated. And there was no other intervention as in the other cases that you cited in your brief. And I'm trying to get why the retreat is so important to you in a time frame.
My reading of those cases that are cited in the brief is that what separates those attempts that are cited in the brief from completed acts are that there was intervention from someone else, right? That but for the intervention of someone else, these crimes would have been completed. That but for the plans being foiled, the crime would have come to completion. And we're simply saying that's not what happened here.
Okay, so what if he goes to bed and she didn't contact her boyfriend who contacted her mother? What if that didn't happen? What if he goes in his bedroom and says, I'm gonna go back in there and try again? I mean, I don't see why that is so important to you, because there was ultimately intervention here, whether he knew it or not.
Right, but the intervention, I guess our argument is that the intervention is what cuts off the action. In each of those cases that are cited in the brief, it's the intervention that cuts off the defendant's actions. But in this case, it's not the intervention that cuts off Mr. Wheeler's actions. It's his own intervention that cuts off the action.
Well, in reading your brief, I kind of took issue with that, because if you kind of expand your argument to a further logical conclusion, you would be saying that you can only have an attempted rape not if the victim is strong enough to fight off her assailant. You can only have an attempted rape if a third party comes in and stops the attack. I mean, the victim can, quote, be strong enough to stop the attack, and therefore be the fact that stops the crime and makes it an attempt as opposed to a completed action. So I understood the cases you cite, but the law doesn't say a third party has to be the one that stops it, because otherwise, again, you're telling me that a victim who fights off her rapist and keeps him from actually completing the act, he can't be convicted of a crime because a third party didn't intervene.
Not at all. And I actually did cite some cases in the brief where it was the victim who intervened on their own accord. So that's not what we're saying. I think there's a differentiation between a victim physically fighting off her assailant and the victim in this case simply saying no. It's not, it's not just that, he asked and she said no, and it's, shucks, and that's it. I think that there's a differentiation between that and the victim phically fighting off the assailant. So no, absolutely. In those instances,
But he did more than ask. But he did more than ask in this case. I mean, I would agree with you maybe I would agree with you if an adult came to a child and asked for sexual favor and she said no and he walked away. Okay, maybe you got a better case of, is this really an attempt to solicit a minor or attempt at statutory rape? But he did more than just ask. I mean, he made several comments. He made several acts towards her. There's more than just a question of, hey, you know, let's have sex. He did more than that.
We have run out of time with all of our questions. What I will do is, Ms. Butler, is still allow you 2 minutes of rebuttal so you can group things back together and make any final points you want to make. And if
Thank you, Your
something's
Honor.
raised anew, General, that you need to respond to, we'll let you respond. But let's hear from the appellee now.
Judge Thomas, can I ask one question before we go to the appellee?
Of course.
I just have one. The argument on the next issue, which is the attempt to solicit.
Yes, Your Honor.
Is that you don't have to go into your entire argument of why it's okay. Is that waived, or can we not consider that just a sufficiency of the evidence question, and therefore we don't even need to go to plain error?
Absolutely, and that was part of the argument, is that it's not waived. You can absolutely make that consideration without getting to the plain error analysis, although that is in the brief.
Thank you.
Thank you.
Thank you, Judge Thomas.
Yes, sir. All right, General.
Good morning, Your Honors, and may it please the court. Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the defendant's convictions for attempted aggravated statutory rape and attempted solicitation of a minor, as well as his respective sentences for those convictions. Your Honors, my interpretation of the defendant's argument, it appears the defendant is conflating the attempt law with conspiracy law. There was no need for the defendant, whether or not he withdrew to back into the bed or whether there was intervention, is frankly not very relevant, because it's the state's position that, based on the precedent of State versus Fowler and other cases, that all of the defendant's individual actions were each a substantial step, and that the jury could have looked at any of those actions individually or together and reasonably concluded and found the defendant guilty beyond a reasonable doubt of attempted aggravated statutory rape.
Well, aren't we running really close? We're running, this case is forcing us to really blur the lines to a certain degree between attempt stat rape and whatever attempt solicitation is to solicit a minor, because it is unclear when you're attempting to just verbally communicate commission of sex with a minor, and when you go further. And I think that's what I was struggling with when I was reading the briefs in this case, because you really did have to look at, was the defendant just talking, was he expressing himself, blowing a lot of hot air or whatever, that kind of conduct, which falls within the realm of solicitation, versus truly an attempt to engage in sex, the act of sex. And I think this case is probably the closest that I've seen where you got the blurring of those lines. Can you speak to that, counsel?
Yes, Your Honor. The facts here show that it is clear that the defendant intended to attempt to commit aggravated statutory rape. Not only did he have those verbal solicitations, as you mentioned, Judge McMullen, he approached the victim, BG, with a note that said, "Do you suck?" Then he rubbed her head, as you noted earlier. And when the victim expressed confusion, he said, "You know what I mean." And then he said, "Just think about it." Then he went into the bathroom, came out of the bathroom without his pants on, exposing his penis to the victim, and said, "So what?" He continued to verbally ask the victim to perform fellatio on him and said, "So are you going to? Nobody will know." And as you noted earlier, Judge McMullen, he was touching himself as he was asking for oral sex from the victim. Based on all this evidence, the jury could have reasonably inferred that the defendant intended to commit fellatio with the victim.
So speak to what an attempt, because solicitation is an inchoate offense. So speak to what counsel refers to, and I guess her second argument, more difficult time with, how do you attempt to solicit? Did you understand my argument?
I believe so. The audio cut out for just a minute, but if I could reiterate your question, you're wondering about the defendant's contention that it's legally impossible to commit attempted solicitation of a minor?
Yes.
Certainly. Well, first, it's the state's position that the defendant has waived this objection because he failed to object to the trial court's instruction.
Assume it's not waived.
Yes, Your Honor. Assuming this, the case of State versus Kimbrough is helpful in analyzing this issue. And in that case, the Tennessee Supreme Court in 1996 clearly held that attempted felony murder is not an offense, and kind of it addressed your question, Judge McMullen, and said you cannot attempt to attempt. And the court looked at two main components of this issue when it made that ruling. It noted that the mens rea for attempt is intentional, whereas the mens rea for felony murder was recklessness, negligence, knowing, or intentional. It had any of those mens rea would suffice. And so the Supreme Court said you cannot have an offense that you cannot intend to commit a reckless offense. You cannot intend to commit a negligent offense. So the mens rea was part of the component of why you could not attempt to commit felony murder. Additionally, the Supreme Court noted that the legislature had already created offenses for those situations where someone had been injured but not murdered, such as aggravated assault or simple assault. However, here, this case can be differentiated from Kimbrough. When we look at the offense of solicitation, the mens rea required for solicitation is intent, just like attempt. Thus, we don't have the problem that was present in Kimbrough. Additionally, the legislature has not created an offense to address this situation. So there is a need for a lesser included offense. Additionally, it is noteworthy.
Are you saying it is possible to attempt? Because I'm not finding in your response an answer.
No, Your Honor. Attempt is not possible, but that's also not what we have here. Here we have attempt to solicit.
Okay, is solicitation not the attempt to engage in the underlying or the attempt to ask or entice or persuade the victim to engage in the underlying offense, whatever that might be? Is that not what the statute says explicitly?
The statute says that solicitation means to intentionally command, request, hire, persuade, invite, or attempt to induce. So the defendant is correct that the word attempt is in the statute, but this does not defeat the state's argument. Attempt to induce is only one modality or means of committing solicitation. And the offense of solicitation of a minor is not included in the chapter with the inchoate offenses. Rather, it's included in the chapter with the other sex offenses, showing the legislature's intent to separate it from the other inchoate offenses.
You're separating the inchoate offense of solicitation of a minor from attempt, or you're chopping up, I think, solicitation from I guess the minor piece, or the fact that there is a solicitation of a minor still requires an attempt to engage. I guess I'm losing myself because we're double speaking here. We're actually triple speaking here. So you're saying because it's in a different place, the substance of solicitation of a minor, that means that you don't have an attempt to solicit. If that makes sense. You're hinging the success of your argument on placement of the statute.
Only in part, Your Honor, in the fact that it shows the legislature's intent to separate solicitation of a minor from the inchoate offenses. Thus, because it is separate, we need the option of having attempt to solicit as a lesser included offense.
So what are we punishing by doing that? I mean, I don't even know the conduct that you're asking a jury to punish. Is that even possible? Because the solicitation of a minor in and of itself is punishing the thought of engaging in the act of enticement with a minor. So by allowing the attempt to solicit, what is the behavior that we're punishing?
Yes, Your Honor. Obviously it's unclear exactly what the jury was thinking, but the jury could have inferred that because the note was not found, that the defendant's solicitation was not completed. Or maybe the jury looked at, as the defendant has noted, that he got back into bed and considered that it was an incomplete solicitation. I mean, it's unclear. And
I guess maybe as I hear Judge McMullen's question, I think her question is, but what are we punishing? What behavior is different between solicitation and attempt to solicit? The way you're describing it, it's the exact same behavior. So what behavior are you punishing by under the lesser included offense? It's different than what you're punishing under the greater offense, as you pointed out.
Yes, Your Honor. It would be an incomplete solicitation. Which, again, here it's hard to discuss the legal concept without looking at the facts. But
are you saying we're talking about, I kind of want to have sex with you to a 13 or to a minor? I kind of want to. Is that the? I mean, I'm laughing, but really, as a practical matter, you have to identify this, to make sense of it, because the defendant's argument is it is impossible to have an attempt to solicit, and you're struggling to answer the basic question. What was he punished for? And what would we punish an individual for if we upheld this conviction?
How do you attempt to ask something? How do you attempt to entice someone? And with the solicitation, by definition, the ultimate act never occurs. So it's, anyway, that's what's bothering me about this. What is an attempt to ask? What is an attempt to solicit?
Yes, Your Honors. I understand your concern. And it's the state's position that, again, that maybe the defendant made some substantial step by writing out the note, "Do you suck?" but then never delivered it. Or for some reason that overture, that command, that request that is outlined in the statute was never completed. And again, here the jury could have looked at the fact that that initial note was never found and concluded that based on that fact that the solicitation was incomplete. But it's that act of a substantial steps towards that command and inducement.
But if the note, if the jury's saying, using your argument, the jury's saying that because the note was never found, they're basically questioning the existence of the note, then that really is a true, either he's guilty of the indicted offense or he's not guilty, because either he wrote the note and asked the question, or the note doesn't exist. I don't see where the gray area is. Well, he wrote the note, but we don't see it. And so he didn't really ask the question. He either wrote it or he didn't, and she saw it or she didn't. So I don't see where you're making out this gray area. I don't see where that exists. It's either guilty of the indicted offense or it's not guilty of the indicted offense, if you're relying solely on the quote note.
No, not specifically, Your Honor. And again, it's hard to speculate as to what the jury was looking at, but again, it's the fact that he was attempting, he took those substantial steps towards inducing the victim to have oral sex with him. That's what the state's position is, that the offense is.
That's what the
defined
that's
as.
what the attempt ag stat rape is, and that's what I was getting at earlier. You are blurring the line in this case, and I don't think that's possible. The defense has a very strong argument. They already are arguing that there was no substantial step in the attempt to, engage in the statutory rape. And so, but you're arguing both facts in support of the attempt to solicit. And that's a big problem here.
Your Honor, and that's why the state concedes that this court should merge the attempted solicitation of a minor conviction into the attempted aggravated statutory rape conviction under this court's precedent in State v. Smart and Tennessee Code Annotated 39-12-106, because the state did rely on the same factual basis for both convictions.
So you're saying we don't even have to reach the issue of the attempt to attempt?
No, Your Honor. But the end result, the state concedes that these convictions should merge.
I mean, so the end result, minus having this random attempt conviction on his record, the end result is the same. He's going to have 6 years for the aggravated statutory rape or attempted statutory rape.
Yes, Your Honor. And moving to the defendant's sentencing issue that Judge Dyer has mentioned, the state's position is that the trial court properly imposed confinement in this case. The defendant's sentences were all within range, and thus this court should presume that the sentences are reasonable. And here, confinement was proper. The defendant was eligible for probation, but he was not a favorable candidate because he was a Range 3 career offender, and he had an extensive criminal history. And here, the trial court considered all the proper factors, which weighed against a grant of probation. The trial court focused on the defendant's lack of potential for rehab. The defendant had numerous prior felonies and misdemeanors, such as harassment, public intoxication, domestic violence, DUI, felony escape, aggravated burglary, aggravated assault, and attempted first-degree murder. Additionally, the defendant was serving a probated sentence when he committed the instant offenses. The trial court noted that the defendant had multiple opportunities to complete an alternative sentence, but was unable to do so. And so the trial court concluded that society needed protecting from the defendant. And to quickly address the defendant's issue as to the sexual offender evaluation, in State v. Tulloch, this court concluded that the defendant had waived a very similar claim that the trial court did not consider an evaluation because the defendant failed to object during the sentencing hearing. Additionally, in State v. Good, this court concluded that the defendant could not show that his sentence of confinement was improper when there was no showing that he even submitted to an evaluation or presented that report to the court. Thus, the defendant has waived this claim, and plain error relief is not appropriate here. So the state asks that this court affirm the defendant's sentence and the imposition of confinement. And unless this court has any further questions, the state asks that this court affirm both convictions and the sentences.
Thank you very much.
Thank you.
All right, appellant, you have 2 minutes to bring all that together for us.
Thank you, Your Honor. So I want to briefly touch on Judge McMullen's point about blurred lines. And that really comes to the heart of the problem here, is that the state, both at trial and here again on appeal, is blurring the lines between what they consider to be an attempted aggravated statutory rape and what they argued was solicitation at the trial. And really, that's our position as well, that the facts as they are presented potentially did constitute a solicitation, which he was found not guilty of. But they absolutely do not constitute an attempt at aggravated statutory rape. That these are absolutely lewd comments, uncouth behavior, but it is not an attempt to commit a statutory rape. The second thing is I believe I heard Ms. Simpson say that the legislature has not created an offense to address this issue. As far as we're concerned, that is where this should end. It is not an offense, and therefore he could not have been convicted of something that is not on the books. As far as we're concerned, full stop right there. This is an illegal impossibility, and Mr. Wheeler's conviction should be vacated on that basis alone. And I'll leave it there. We'll rest on our brief with respect to the
Let me ask you about the sentencing, the psychosexual evaluation.
Yes, Your Honor.
If the defendant didn't object to the fact that that wasn't included in the pre-sentence report that the trial court considered at sentencing, have you waived it? And is my first question. And if you haven't waived it, then is it abundantly necessary? Can we not get to the same conclusion or review the sentence without the psychosexual evaluation?
So I do not believe that it's been waived, Your Honor. This is a statutorily required element of a sentencing hearing. This is not something that the state can say is unnecessary. It's on the books that they have to complete this psychosexual evaluation. And the failure to do so, I think it gives the court an incomplete picture from which to review and determine what the appropriate sentence is. So yes, I think in theory, this court could look at everything that the trial court had in front of it when it made its determination. But it's our position that that's an incomplete picture, and that the psychosexual evaluation could have potentially provided some really key insight that may have changed the trial court's determination about what the appropriate sentence should have been.
So let me ask you this then, kind of based on your last point. Based on your client's record, which is clearly what the trial court hung its hat on in reaching its determination, what, if anything, in a psychosexual evaluation is really going to, if we remand it back, is really going to change this trial court's mind based on the extensive record of your client and the fact that he was on probation at the time he committed the offense? I mean, there are lots of reasons to why the trial court got to where he was that are completely legitimate, and you don't really take issue with a lot of the things he said. Your main thing is the lack of the evaluation. So is the evaluation really going to change the outcome of this? Sending it back for him to look at an evaluation, is it really going to change the outcome?
It may not, Your Honor. If the trial court is absolutely, has dug its heels in and has decided that Mr. Wheeler is unfit to serve probation due to his record, certainly sending it back for a remand on the psychosexual evaluation may not change the trial court's mind. Our position is that the psychosexual evaluation potentially could have provided some key insight that may have changed that determination, and we just don't know.
Okay. Thank you.
Thank you so much, Anna.
Thank you very much. You both had portions of your argument that were very difficult to deal with, and I think you both did a good job. So thank you very much. Mr. Clerk?
This honorable court is now in recess until 1 p.m.